Our next speaker is Preston Byrne. Preston is a crypto anarchist, marmot herder, and technology transactions lawyer at Brown Rudnick, LLP's Washington, D.C. office. He's a columnist at CoinDesk. He advises businesses in Bitcoin, crypto, consumer internet, and dissident tech sectors on a range of contentious and non-contentious commercial law matters. He's a pretty good follow on Twitter. Last year, he prepared a speech for us called How to Protect Your Bitcoin Citadel from an Invasion of Space Marmots, but he was unfortunately not able to make it here. So we'll see what he has this year in store for us. Ladies and gentlemen, it's Preston Byrne.
You know, I apologize for not being here last year. So a friend of mine was like, hey, there's this super elite crypto conference happening at Jackson Hole, and like all these VCs are going to be there. I said, what day is it? He's like, March 4th. And I was like, no. I stood these people up last year, and if I don't go give my speech at that Best Western in Manchester, New Hampshire, they'll never forgive me. So here I am. Anyway, so yes, as I said, as everyone said, my name is Preston Byrne. I'm a lawyer. Before we begin, here's my firm's standard disclaimer, which is I'm not your lawyer and this isn't legal advice unless an engagement letter has been signed and the retainer fee has cleared. So now that we got that out of the way, in terms of like who I am, I'm British educated. It's all wonderful. I practice law in England and the US. I'm a partner with a big law firm in DC. And basically, I'm a radical anarcho-capitalist who completely sold out, wears a suit, and keeps my mouth shut in public. So I'm a sellout, essentially. And I practice law, and I advise people who are crazier than I am who aren't sellouts, which is why a lot of them are richer than I am as a consequence, and were into Bitcoin before I was. So what we're going to do today is we're going to do just a barnstormer. We're going to run through very generally a lot of business law topics in crypto that both from like the contentious side and the non-contentious side, the transactional side, just sort of give you a very general overview of what's going on because crypto is a huge business, so it's impossible to cover it all in one talk. So we're going to cover sort of the high notes as best we can. And so there you go, ranging from what is crypto all the way down to things like sanctions law. So here we go. All right, part one, crypto commercial law. So what is crypto in the eyes of the law, right? So for a long time, it wasn't actually clear what crypto was. So and by this, I mean, if you had crypto on Coinbase, and let's say you wanted to get it back, you wanted to sue Coinbase, right? There's a contract which says that you give the crypto to Coinbase. Coinbase has to give it back to you. And there are all kinds of disputes where this stuff was involved, but nobody actually asked the fundamental question, well, what actually is the thing that Coinbase has that you need to get back? Right, what the foundational question of what the property was and what the legal treatment of it was never really asked for the first couple of years. Now, the English figured this out a couple of years ago. They said, hold on a second. We have two categories of property in English law. We have choses in action, things in action, which are enforced by court judgment. And we have choses in possession, which are things that you can hold on to, tangible stuff like this or, a chair or that dog over there. Those are choses in possession. And they said crypto is neither of these things, right? Because it's intangible. You can't hold it. It's not something which you can go and enforce in court, like, for example, traditional intangibles like a security. So what is this thing? And so the English have actually said it's a third category of property. I call it crypto property with a K because the one thing which distinguishes crypto property from everything else is the exclusive knowledge of a secret, right? The private key, which nobody else has. And so that secret, if the secret is destroyed, right, if someone else finds out what it is, you've got a problem, right? And that's how crypto works. But that, I think, is the essence of it. And so you can build on top of that, right? And you can say, well, what happens if someone misappropriates the secret? Let's say a trustee has a key and they reveal the key to somebody else. Then you can use something like a breach of trust theory to go and get at the trustee for damages for the Bitcoin that they lost. So, so basically, in terms of the law that's involved, the UK has actually written some extensive position papers on this. It came out in July of last year, so something worth reading. In terms of the US, we haven't really seen the courts deal with it at all. There are a couple of sort of law school first-year cases that you can take a look at, which would illustrate how a court would look at this. The first is Pearson versus Post, which is a case about capturing a fox and who owns a fox that's running across various fields. The second one is called Popov versus Hayashi, which is a much more interesting case. So basically, Barry Bonds hit a home run. It was a very significant and meaningful home run, right? And the guy on the right, Popov, caught it in his glove. But then, of course, he was mobbed by 20 other rabid baseball fans who knocked it out of his hand. The ball bounces across the room. He's sitting there going like that, right? And then this guy, Hayashi, on the left, picks it up, and he goes, well, this is mine now. Excellent. So Popov sued Hayashi and said, no, it wasn't. I was the rightful possessor of the ball. And the court had to figure out who actually owned it, right? Because as soon as Barry Bonds hit it, right, it was abandoned by Major League Baseball. It was no longer theirs. They had no intention of getting it back. So this doctrine called relativity of title applied, right, which is where you look at who has the claims to the thing, and then you measure those claims relative to one another to arrive at a conclusion as to who owns it. So with crypto, right, if a Bitcoin is mined, right, and you mine it, nobody gave it to you, right? The Bitcoin network gave it to you. No person did. So if you then spend it, right, on something else to somebody else, and then, oh, I'm sorry, are you fussing? Is he? If you need to, you can bring him up, and I'll hold on to him. So anyway, so long story short, relativity of title is a doctrine which is important here in the United States. So that's that. And cryptocurrency is money, and we'll talk about why that's important later on. So next topic is contracts, the type of contracts that you should expect to encounter if you're involved in crypto agreements. And generally speaking, what I find is that they fall into three types, well, really four types of agreement, but one of them I don't include here for brevity. The first are investment agreements. You're investing in a startup, you're investing in a company, you're going to see these documents, I'll tell you what they are. Second one is software licenses, and the third are other type of copyright licenses that you'll see as a retail consumer. So the investment agreements tend to be, yes, we do. So those tend to be things like safes and equity agreements, convertible notes, token warrants, and we'll talk about what those are in a second. So if you're an early stage company, or if you run one, right, a little startup, and you need to raise startup capital, what you have to do is you have to get an investor to give you money, right? And that investment is going to be on some particular set of terms. Generally speaking, what we see in crypto is that most companies that start up use a thing called a SAFE, or a simple agreement for future equity, which is basically a forwards contract where, is he being, hi buddy, hi bud, I can hold on to him if he's fussing. Yeah, I'll just hold on, I'll just bring him over here. Does he? Okay. Anyway, I brought my dog to the do you want to come up? You want to come up? Come on, just pick him up and I'll.
Doggy coin.
Yes, doggy coin.
I'm sorry, I tried.
That's all right. Right. So forward. So what we tend to see are safes. Those are the main type of contract that you'll see with startups. They're about 5 or 6 pages long, very short. They have 3 principal terms, whether there's a cap on valuation, a discount from the next round, or something called an MFN, or a most favored nation provision, which basically says, if you give another investor a deal which we think is better, we can elect to choose that deal. So that's what you usually see with startups. You also have venture debt and convertible notes. LOL, basically the last convertible note I negotiated was at 6% about a year and a half ago, and that was considered expensive. But of course now 6% is closer to the base rate than it is to a commercial loan. So I think venture debt's probably not a good idea for most early stage companies at this point. There are various routes that you can do this lawfully. Reg D is a private placement exemption where you sell notes to rich people. Reg CF is a crowdfunding exemption, so you've got things like Start Engine and other companies that allow you to sell directly to the public. Reg A, you can sell up to 50 million in securities to the public. And then there's Regulation S, which is basically a safe harbor if you're selling things to non-Americans, which you see with a lot of crypto companies because the American regulatory environment is so punishing. And then there are tokens, right? So I presume everyone's seen ICOs, initial coin offerings, you know what those are. Those usually, so they're still being sold, right, and pre-sold, but what we generally see is they're being sold to offshore investors, and there are covenants which say that you can't sell the stuff in the United States. Those take various different forms, warrants, side letters, something called a simple agreement for future tokens, which is widely disfavored at this point. But so we're seeing a lot of that out of the BVI and Cayman. Europe is passing a regulation called Markets in Crypto Assets Regulation, or MiCA. where they're going to normalize the treatment of those things. So, the rest of the world is moving on, and the U.S. is just choosing. What is that? Is that tasty? It is. Okay. So the rest of the world is moving on, and the U.S. is not. It's a very difficult place to do business. So in terms of software licenses, all software that you use anywhere is licensed, right? And a license is a contract, and that contract determines what you can do with it. And so in crypto, in comply or die, if you're using software and you're not supposed to be using it, or you incorporate software into your code and you don't have the permission to do it, that can cause huge problems down the line in the form of a copyright infringement lawsuit. So generally speaking, we have 3 or 4 types of open source software in crypto. Proprietary licenses or not releasing source code is widely disfavored because it doesn't allow people to do security audits. So MIT is the most libertarian, I think, of the bunch. It's very short form, which is very good because developers don't like looking at contracts. They just like looking at okay, it's a paragraph, sounds good, cool, never think of it again. There's a little more left to interpretation. If you hand a developer a 20-page agreement, they'll just their eyes will glaze over and they'll walk out of the room. So it leaves open more to interpretation. It's not, it gives a lawyer heart palpitations, but it's good enough. Bitcoin D is licensed MIT. So Apache 2, I call MIT with a suit on. It contains a patent grant specifically, which says that if one of the contributors later patents their invention, they're not going to go after anyone else who uses it as part of the open source software. I don't think there are too many drawbacks to it if you're looking for just a bare bones, open source license. But we see a lot of projects, Cosmos, Tendermint, are licensed Apache 2, for example. GPL3 is what I say, if Justin O'Donnell were a software license, I think GPL would be what it is. And so the reason is because it's very unpopular with banks and corporations, kind of doesn't fit in a regulated or tightly controlled setting, and kind of likes to do its own thing. What? I can't hear you. Moving swiftly on. So the main distinguishing feature of GPL is something called copyleft, which is that if you take GPL code and you modify it and then you put it into your own software and you distribute that software, you have to release the corresponding source code, right? That you took. So you took someone else's source code, you modified it. You got to release the modified source code, and then in addition to that, you've got to give everyone permission to use the modified source code. And so this is cool because it keeps the software free and open. It's not so cool because there's a risk that if you incorporate it into some other piece of software that that you really don't want to be out there, that the software that you mix with the GPL code could itself be infected by the GPL license. So there's something called GPL infection. It hasn't really been litigated very much, if ever. But that's a risk. And so if you'll find that banks and things, that's why Ethereum now is Apache, or most of the implementations are Apache, because the Go implementation, which was the only one that worked back in 2014-15, was licensed GPL. So Consensus had to do an Apache license version in order for anybody to use it. And then there's AGPL, which is GPL for web applications. Basically, if you use the code, you distribute on an app rather than distributing this code itself. You've got to share your corresponding source. Mastodon is an example of AGPL. In terms of creative content licenses, so we're seeing a lot of stuff with NFTs. Everybody here heard of an NFT? Nod up and down. So anybody not heard of an NFT? Yeah. So an NFT is a tokenized piece of artwork, basically. So if you've seen those Bored Ape pictures that people have on the internet, it's artwork that you buy and it has a cryptographic address where it lives. And so people are doing that. And so my sister and I were talking about this the other day. And she said, so let me get this straight. I was like, yeah. So I gave someone a marmot coin in exchange for a marmot painting. And so I went, okay, cool. I'll give you the marmot coin and you give me the NFT of the marmot painting. She said, let me get this straight. So you didn't get the actual painting? I said, no. All right. And you invented the marmot coin? Yes. And you gave the thing you made up to the thing the other guy made up. And you didn't get any rights in the painting or anything. He just gave you the NFT. It was like, yes, that is exactly what we did. So it's crazy, but it's happening. Generally speaking, you have to look at the license which accompanies the NFT. So again, let's imagine it's just digital art on the blockchain. If it has no license, bad. If it has a commercial license or a license which allows you to use it commercially, That's pretty good because it means you can use that NFT in your business or something like that. Projects like Yacht and Bored Ape Yacht Club have commercial licenses. Non-commercial licenses you see a lot of. Those generally are for properties that are owned by some other big property aggregator like Hearst or Warner Brothers or something like that. They don't want you going and competing with them and making merchandise, and they have competing arrangements. So that'll be for your personal non-commercial use if you buy a Walking Dead NFT, for example. And then there's no license needed, which is for AI art. So the image on the right is from a comic book called Zarya of the Dawn. It's a graphic novel for children. It was written by an author, fair enough, but then it was illustrated by Midjourney. So the author went to register the book with the Copyright Office for the purposes of protecting her copyright. And the Copyright Office said, yeah, it wasn't made by a human, therefore it's not copyrightable. So we will grant the registration with respect to the book and the text, but not with regard to the AI, which is interesting. So all that AI work which is floating around is not copyrightable. It can be used by anyone in the view of the U.S. Copyright Office. Anyone heard of a DAO? Show of hands. DAOs? Okay. And so anyone not heard of a DAO? Show of hands. All right. So a DAO is, I call it a general partnership for bullshitters. Basically, it's a way that holders of coins on a blockchain can coordinate their activities through the software rather than through a contractual agreement. So they can say, we will do voting where we will put the coins in and we'll vote whether a project should be funded or not. And a majority vote, will mean the project gets funded. And if it doesn't happen, the project won't get funded. So I actually helped to build one of the early ones of these. There have been lots of them: BitShares, The DAO, Maker, Moloch, yada, yada, yada. And they're, in theory, right, what they're aiming at is to replace the corporation. But it hasn't happened yet so far. The problem with a DAO is that they try to do the things of a corporation without the protections of a corporation. And the chief protection of a corporation is that it confers limited liability on the members. So the members are not liable for the debts and activities of the corporation. If you run a company and you're or if you're a shareholder of a company, right? You're a passive shareholder, let's say of, I don't know, Monsanto, and then Monsanto goes and poisons a country and they get sued, right? They're not going to be able to reach through the Monsanto entity to you as the shareholder because you've been conferred with protection through limited liability. There are some circumstances where that doesn't happen, but generally speaking, that's the rule. So the problem with DAOs is that it's two people engaged in business, right, with a view to profit in most circumstances. The law calls this a general partnership, and what it does is it confers joint and several liability on all of the partners automatically, which means every partner is liable for all of the actions of the organization, right, which is problematic. So there was one called UkiDAO, which, stupid name, we actually filed an amicus brief in this case. There's a DAO with 40 members or so, and they were offering derivatives products, which is a big no-no under the U.S. derivatives laws. The CFTC sued the DAO, only identified 2 of the members, so 2 of the key holders, and then, after that, defaulted the DAO because the DAO didn't answer the case. And the two I think U.S. members that they managed to serve, which couldn't afford to challenge it. So basically, they found 2 people who were doing this software thing, sued the software thing, gave general notice via Twitter and other things that the lawsuit existed. There were challenges as to whether that was valid. Court said it was, and they went and they said, okay, cool, we're going to get a default judgment against you. So this is all part of a wider U.S. sort of unfriendliness to DAOs, and so it's not a good idea to open them until that unfriendliness is resolved. Switching up the dog holding arm. Crypto litigation, there's not a lot to say here. If you get people in crypto, they make a lot of money, they lose a lot of money, they sue each other. So basically, here's some just pointers. If you do happen to get involved with a very lucrative business, the more money there is and the more successful it is, the more likely it is that you're going to get sued. Anything you put in writing will be disclosed. Doesn't matter. It could be on Facebook, it could be on email, it could be whatever. The other side or the SEC or whoever else is going to get a search warrant or a subpoena, and they're going to get that information. So if you don't want something to be known, don't write it down. This is not a personal privacy issue. They will wring this information out of you with their bare hands, right, if they have to. So just assume that that's the case. Signal's really the only safe bet for encrypted communications. Stuff like Discord, it's all stored in the clear. Facebook, Telegram, same thing. Not to be trusted. for anything secure. But again, if there's something you don't want the world to see, if there's something you don't want in front of a judge, don't write it down. Because if you write it down, it's going to be in front of a judge. What's that? Yeah, tweet it at the judge. Or you could tweet it at the judge, like someone who shall remain nameless. You could just, we're in proceedings with the biggest, baddest, scariest government in the world. We're just going to be like, fuck you, buddy. I wonder who that is. So turn off, if you're in litigation though, turn off auto-delete. Or if you're under investigation by the cops, turn off auto-delete. Reason for litigation is there's something called spoliation of evidence. So you'll be held liable for wrecking the evidence if you delete it. In the criminal context, that's obstruction of justice. In the U.S., that's a lengthy sentence. In England, that's a potential life sentence. So you don't want to do that. And don't talk to the other side. STFU. I'm not going to tell you what that means. But basically it means shut the up, right? So the reason you don't... So I've had cases where people have really good, strong claims, right? Then they decide to tweet about it. Not anybody in this room. We're talking about somebody else. So they decide to tweet about it, or they decide to email the general counsel of the other side to yell at them, right, about the things in the case. Or they decide to go behind my back to contact my client to say, on the other side's case, to contact my client and say, we really want to have a conversation with you without the lawyers, after being specifically directed, do not talk to my client, you are to talk to me, right? Those are the kinds of things that will take a perfectly strong case and will ruin your chances of winning it, so don't do it. And this is the regulatory landscape. We may recognize this from the 2000s era hit Constantine. I don't need to tell you what that movie was about. I assume most of you have seen it. So developments in securities law. So securities law in the U.S. is very aggressive and very hostile towards crypto. Broadly speaking, if you sell something and the person who receives the thing you sell thinks they're going to make money from holding on to it and later selling it, it's probably regulated under the Securities Act of 1933. So, the merits of that are debate for another day, but that's the facts where we live. In 2017, I watched a lot of my friends get stupidly rich selling shitcoins all over the world. Tezos, Ezos, other mega shitcoin schemes. Shitcoin is a term of art in the business. And then in June 2017, I was actually at PorkFest when it happened. The SEC released something called the Dow Report of Investigation, which basically said, hey guys, you really shouldn't do this. This is really not a good idea, selling these coins. It's probably going to be covered by the securities laws. And then nothing happened. So everybody kept selling the coins because the SEC didn't enforce. Finally, in November of 2018, the first enforcement actions came down against Paragon and AirFox for selling tokens, Floyd Mayweather and Khalid, who are here for shilling tokens, and Ether Delta for operating a decentralized exchange. And that was sort of the shot across the bow to the industry. It was widely ignored. And so now we are where we are 5 years later, where the SEC basically has determined to declare war on the industry because they keep enforcing, but new projects keep cropping up because everybody wants to do this stuff. Do you mind, buddy? Thank you. So the cases, if you want to look at the cases which are interesting, 2019 was Kik Interactive. Kik was a messenger service that was failing and going out of business. So Union Square Ventures said, hey, go launch a shitcoin. So they raised $100 million and then they had to give it all back. So that didn't work out. In 2020, there was Telegram Inc. and Ton Issuer Inc. I saw the investment documents on that deal. So basically the investment documents said, we're going to raise the money from you. We can use it for any purpose we want, including our general business expenses and nothing to do with the token. And if this doesn't happen, you're not going to get your money back. So they raised $1.7 billion. They gave back 1.2. So they got $500 million out of the deal. And the SEC filed an emergency lawsuit against them. Filed an emergency lawsuit against them in order to prevent them from flooding the U.S. market with their tokens. And then in 2022, of course, Library Inc. happened right here in the District of New Hampshire, where a righteous member of our community who is rightfully aggrieved about the outcome of that litigation, had an actual application with an actual use, right? And an actual application that used the token in a consumptive function. And the SEC, some presumably ambitious attorney out of the Boston office, decided that it needed to be stopped. So that is unfortunate. So in terms of what to look out for, what's coming next, I'll just blast through this. Ripple Labs is the next big case. They're going to lose. I know their XRP army on Twitter says they're not going to lose. They're going to lose. Paxos and BNB recently were on the receiving end of some enforcement actions under the New York Martin Act and allegedly under the Securities Act. So keep an eye on that. The Exchange Act is another one. So if someone walks up to me and they say, hey, Coinbase, if all these things are securities, then isn't Coinbase a national securities exchange? And I go, yeah, they should be. Like, why are they selling them then? I don't know. I mean, if they were obeying the law, they wouldn't be. So I would expect that there's going to be some movement on that in the next year or two. So DeFi enforcement, we're going to see a ton of that. But most interestingly, we're starting to see our crypto native providers of financial services who are integrating, for example, MetaMask into a broker-dealer application or an ATS trading system. So currently the only game in town there is INX. Watchdog Capital in the other room, they have a broker-dealer license. They're not an ATS. And I'm starting to see new entrants who, in view of the regulatory movement, they're starting to open their own businesses and get licenses to service crypto in a legally compliant way here in the U.S. It's annoying, but that's the way it's going to be for at least the next 5 years. Criminal laws relating to money. Excuse the terrible formatting. So don't steal. Stealing is bad. If you steal over the internet, it's a federal crime. If you defraud someone using email, that's a federal, and that email crosses a state line. I've had the FBI reach out to me for certain clients and say, hey, can you confirm that your server isn't in the state of Florida, right? And the reason and you have to write a letter. Yes, we confirm the server's not in the state of Florida. It's in the United States. Why? Because they're doing an investigation. They need to see if they have jurisdiction. And so what they do is they say, could you please let us know where your server is so we know whether we have jurisdiction? It's a very common practice for law enforcement to get this confirmation from communications companies. Don't lie to banks. It's a very bad idea to lie to banks. If you lie to banks, you can lie by omission to banks. So, for example, if someone says, oh, what kind of business do you do? Right? And you're like, well, it's kind of a software business. Yeah, and it's not. It's a cryptocurrency business, and it's a transaction mixer that launders funds from North Korea, right? You didn't technically lie to the bank, but you did, because basically you told them something, but you didn't tell them the whole truth. So you can commit that offense by omission, and it's something that you need to look out for. Finally, don't operate an unlicensed money transmitting business. United States versus Freeman and others is a case which I'm sure is familiar to many of the people in the room. Relevant point for law reform is that the offense in U.S. versus Freeman, right, relating to Mr. Ian Freeman, who I presume is somewhere around here today, is not an offense in all 50 states. There are 15 states which are no-action states from money transmitter perspective. So basically, if you're buying and selling crypto, those states say, listen, that's not within the scope of our money transmitter laws. So once you go get your federal registration, we don't require you to do anything here by state law. So that's a point where New Hampshire really ought to be right in line with the other 15 no-action states. They've been no action for years, right? So you can buy and sell crypto without a money transmitter, without a money services business license, and it's fine, and the sky hasn't fallen in. So that's something New Hampshire might want to look into. Scams, a lot of scams. So the big ones are listed here. The points of commonality, which I like to point out. First one's leverage. So if there's crypto and borrowing, that's something you really want to look out for, because if someone's trying to take your crypto and they say they're going to do something profitable with it and then they'll give it back to you when they're done with it, that's a bad idea. Stay away. And there's also something called the scammer extinction burst. So an extinction burst, for example, is, let's say you have a pet that wants to do something and you've denied it. So let's say he wants a treat and you haven't given him a treat. You want a treat? You do? Okay, and you don't give him a treat, he'll bark and he'll bark and he'll bark and he'll bark. But if you give him a treat, he'll stop. But if you don't give him a treat, and he's used to you giving him a treat, he'll continue making lots and lots and lots and lots and lots of noise until eventually he peters out. That's called an extinction burst. And we see that a lot with scammers. They tend to be really, really public and really, really vocal just before they get taken down. Sam Bankman-Fried, prime example. He was on Dealbook. He did every TV show under the sun, and then he got taken down. Andrew Tate, another example. He became a big figure in the online manosphere, but then he was arrested for sex trafficking. So that's something to look out for. If someone suddenly has become extremely public, generally speaking, that's not a good thing. So I want you to read that. Yeah. So don't do business. Don't do business with Iran, Cuba, North Korea, or Massachusetts. And tread carefully if you're doing business with Russians, Belarusians, or Venezuelans. Basically, Iran, Cuba, I joke about Massachusetts, but we shouldn't do business with them anyway. But Iran, Cuba, and North Korea, Iran, Cuba, and North Korea, big no-nos. You do any business with a Cuban at all, you can go to jail. You do any business in North Korea at all, you can go to jail. The fellow pictured here, that's a visa to the DPRK, and that's Virgil Griffith. He was an Ethereum developer, and he wanted to go to a People's Friendship Conference in North Korea to teach them all about crypto. And he gave a presentation, right? He just talked. He gave a presentation in the DPRK, and he got a 2-year sentence federal for that. So basically, be really, really careful. If someone's from a really sketchy place, you probably don't want to be doing business with them. Anyway, summary. Basically, winter's here. That's a picture of a nice snowy valley with a nice pretty mountain in the background. But winter is here. The U.S. regulatory environment is bleak. It's likely going to last until a change in presidential administrations, maybe 2 or 3 of them, until you get someone other than a boomer in office. To be dead serious. So the damage in terms of new legislation is likely limited. I don't think we're going to see too many laws targeting crypto, but what I do think we're going to see is a ton of action coming out of the executive, which limits the ability of companies to do crypto stuff in the U.S. And the ability of states to draft crypto-friendly regulations is somewhat limited. So if you turned around and said, well, we're going to make Bitcoin legal tender in New Hampshire, great. That's superseded by the Constitution, which says that power is exclusively vested with Congress. So you have 2 options. Either A, you can pass a different law, like, for example, making New Hampshire a no-action state from NTLs, or B, you can secede. But I couldn't possibly comment on the merits of secession or whether we'd want to secede. But I understand there are a lot of people in this room who think that's a popular option. But basically, the federal government and the Constitution, under our rules and our system of government, if you have a law in the state which conflicts with the federal government, then you're going to have a problem because the federal government will take precedence every time. And that's called the supremacy doctrine. And secession is also unconstitutional, according to court precedents. So you might not want to try that if, for example, you're an attorney or anybody else who's obliged to uphold the Constitution. Probably not a good idea to talk about secession. So crypto winter, probably going to last another year. But of course, given my luck, maybe tomorrow will be the start of the biggest boom in the history of the industry. And they'll be like, Preston talked. He said it was going to last forever. He said we were nowhere near the bottom. Now he's left behind, that dumb son of a gun. But anyway, I think that crypto, the prices are going to be down. But I'm really bullish because what we're seeing is a lot in terms of user acquisition, traffic, and volume on things like the Lightning Network, Ethereum Layer 2, and other projects that are being funded that are building infrastructure. So when the next wave of interest hits, there's going to be a lot more stuff you can do with crypto, which was a big problem the last time around. And the next wave of growth will probably come outside the U.S. LATAM is furthest along. So that's Brazil, Ecuador, Argentina. Africa is actually super, super busy. I have a lot of African clients I have a lot of African clients. And if you look at the demographic trends for Africa, there are about 1.3 billion of them today, and about 4 billion of them by 2100, and the rest of the world is dying out. So I would suggest that in terms of targeting your efforts, if you're looking to figure out which markets are going to be growing and busiest, it's not going to be Italy, right? And it's not going to be Japan, and probably isn't even going to be China. But Africa, definitely. And they did this with cell phones, right? So they leapfrogged the West. If you were in Africa in 2005, right, everybody had cell phones. Not the U.S. did not. So, and the company's MTN, they're everywhere. They just put up cell towers all over the continent, and everyone had mobile telephony, right? Which means then the Kenyans went and did M-Pesa, and then they had digital money. And we still don't have that right here in the West. So it's something where they are going to leapfrog us because there's not the wealth around. There are not the natural resources. There is not enough copper to put into the ground to wire up Africa, right? The earth doesn't have the resources to wire up another 4 billion people. So what they're going to do, they're going to get the tech and they're going to get the infrastructure, but they're going to do it wirelessly and they're going to do it by crypto and other things in a decentralized way. And finally, I'm cognizant my presentation last year was how to protect your Bitcoin citadel from space marmots. That was a title, a working title, while I was trying to figure out what I was actually going to give a presentation on. But then I got COVID, so which was kind of unfortunate. But thanks to the power of AI, I have managed to illustrate a marmot with his space marine buddies coming for your Bitcoins. And so I was working on this afternoon. So if you wanted to know what that presentation would have looked like, it's probably something like this, and maybe I'll give it at some point in the future. All right. Thank you very much. Any questions? Happy to answer them. Good job, buddy.
Preston, you said DAO meant Distributed Autonomous Organization.
Yeah.
I've heard it referred to as Digital Asset Offering as well. Have you ever heard that?
I think ICO, initial coin offering, or IEO, initial exchange offering, is more likely. That's the nomenclature people tend to use when you're selling tokens. DAO, overwhelmingly, I think the majority use case is decentralized autonomous organization or distributed autonomous organization.
Okay, thank you.
Any other burning questions? Free legal advice, which isn't actually legal advice?
I have a question. What are the implications? Like Gensler's been clear about Bitcoin not being a security, but he's now kind of wavering back and forth about Ethereum. What are the implications if he declares it's a security?
I think the horse kind of bolted, right? Like the horse, it's a dead horse, and it bolted. It's up, and it ran out the door, and it ran over the mountains, and the barn door, and it's been open for 100 years. So Ethereum was undoubtedly a security when it was issued, right? They were offering documents. It was called an investment. There were a list of distributors. There was a company that ran it. And then what happened was they decentralized the organization, and anyone who was involved in it went underground, right? Like Mihai Alizzi disappeared in Romania. Anthony Diorio disappeared in Toronto under Snowbank or something. And then the statute of limitations ran in 2019, right? So it would be really hard for the SEC to go back and say it's a security now. It's too much like Bitcoin. There have been too many intervening events for you to really say, that what's the trades that are happening now are governed by the contracts that were issued then. If they were to go after it, I would expect that there'd be a huge challenge. Someone would have standing, and someone would challenge it, likely one of the exchanges, and they probably make some good law out of that case, which would favor us, because that's a bad case. So I think he's hedging his bets because Ethereum started off bad, right, from a legal standpoint. So he can't kind of give it its blessing, because if he did, what happens is 2017. Well, Ethereum did it, right, and they're all billionaires, so why can't we do it? That's exactly what happened. So it was one of those things where, as a lawyer, it's kind of difficult to. It's pretty difficult as a lawyer when the whole market is saying, well, everybody else is doing it and getting rich. What do you think? And you're like, nah, you can't do it. And they're like, all right, well, I'll go hire another lawyer. Anyway, so those law practices, suffice it to say, made a lot of money then, but a lot of them aren't so active now. But yeah, that basically, I don't think Gensler's going to do it. Yeah.
Hey, so I got a buddy out on the West Coast. He's really into crypto, and he keeps talking about Ripple and everything related to it. I don't know a lot about it personally, but you said that it's kind of doomed to fail.
I mean, Ripple may or may not be doomed to fail. I don't know that. If I did know that, I'd be very rich. So what I do know is they're involved in litigation with the U.S. SEC. They're going to lose that case. You can take that to the bank. However, whether if their loss results in the coin price going up, I wouldn't be surprised. It'll just result in U.S. exchanges not listing it, but offshore nobody cares because their laws are different. So,
okay, nice. Okay, I don't know if anybody here really understands what Ripple is. I don't in particular. So, what are some of the implications of Ripple winning or losing?
So Ripple's a cryptocurrency, right? It's a cryptocurrency that was started by a company, Ripple Labs Inc. They made it. They had a bunch of devs. They wrote the code. Thanks. And yeah, so Ripple's a cryptocurrency made by a company. SEC said, and they sold it to the world. The SEC said when you did that, you were selling securities, right? When you were selling those tokens. Ripple disagrees. They went to court. They're currently still in motion practice. Haven't even got to discovery yet. And we'll see what happens. But my suspicion is they're going to lose. So.
Awesome. Personally, if you don't mind giving it, what advice would you give to us as a community to try to find the regulatory environment we want, or the absence of it, in crypto, for crypto?
I would look at easy wins by copying other states that have laws which you can implement pretty quickly. Wyoming, as a general rule, is a pretty good state. So UCC 12 is something that you might want to implement here, which relates to secured transactions. Another thing that you might want to do is you might want to turn this into a no action state from a money laundering, money transmitting perspective. I mean, if you engage in unlicensed money transmission, right, and you're moving the money around, they'll slap you with a money laundering charge because you're engaged in criminal activity. So that generally, if someone gets dinged under 1360, which is the money laundering, or 1390, I can't remember. I think it's 1360, which is the money transmitter statute. They'll also get dinged for money laundering. So you could change that, right? You don't have to have that rule. You can make it so that running a Bitcoin ATM in New Hampshire can be done without a license. You just need to turn it into a no action state.
Do you mind a follow-up question?
Go ahead.
Which hat are you wearing more now, ANCAP or lawyer?
I wear both all the time.
Okay.
When the client's there, my job is to be a zealous advocate of the client and put my interests secondary in all matters, right? So that's the job. I go home at night. I'm an ANCAP during the day. I have some clients who agree with that. I have some clients who think I'm a fascist. I have some clients who think I'm an idiot. But the job is about, and I have a lot of ANCAP clients because I get it. But also my job is to say, listen, we can't live in our fantasy world about the way we want the world to look, right? We have to live in the world we actually have. So it's good to be able to kind of, with an ANCAP client, you can kind of get them over the rainbow bridge from where you are in dreamland, back on solid earth. So,
sorry. Yeah, well, from that vein, like to this community, should we embrace regulation, or is it a less practical road? Is the state going to be the beast we know it's going to be in the end? Or
you should embrace this community. All right, you write this down. This community should embrace making as much money as humanly possible and acquiring as much power as humanly possible in an entirely legal way, because once you have money, right, then you get power, and once you have power, then you can change the rules. So I think there are some who would say, no, we shouldn't comply, we shouldn't obey, we shouldn't run these businesses in a legally compliant way to make a point. And that's fine. And the people who are like that might wind up like Nelson Mandela and spend the next 20 years in prison. Anyone else who doesn't want to do that, if you want to change the way the world works, the only way you're going to do it is by acquiring influence. And the only way you're going to do that is by being successful. And being successful and being a nice person. I think being a good person are the ways you want to do that. So,
thank you so much. By the way, I've been in crypto since 2013. I
Awesome.
don't know that I've ever I'm certain I've never had that much practical knowledge dropped in that short amount of time. Thank you so much.
You're welcome.
Yeah, I have a friend who's a paralegal, and she says a lot of the law firms locally, crypto keeps coming up in cases, business transactions, and they have like no idea like what to do about it. Like, are there some resources for people in the legal community that like primers they can read or places that like they can get some information so they're not going to screw their clients or make stupid mistakes in paperwork?
If they want, they can just call me. I won't steal their client. We can co-counsel. I've been doing this since 2014, so that experience is kind of hard to replicate and put in writing. There's some books, obviously. You should read everything you can about cryptography. Read Schneier's book on cryptography. Start with the basics if you're a lawyer who wants to get into this. But I think the fastest way is just call up a lawyer who does this full time. K&L Gates is pretty good. Drew Hinkes. Sarah Steilman over at Perkins Coie is extremely good. I'm all right. Sometimes. Who else is good? Ben Marzouk over at, where is he? He's at Eversheds in DC. He's quite good. So there are good lawyers around. So just go find them and they'll co-counsel, right? And let you take point and they'll just provide input on the crypto stuff. Yep.
Hi. So you were talking about exit scam, and you listed Andrew Tate as an example. And I just wanted to say something in his defense.
No, thank you. I don't want to hear about Andrew Tate.
So for you to list him as an example, that's just not fair.
I don't care about Andrew Tate. He doesn't exist.
Then why do you talk about him?
Because it's a fact where I can connect with my audience about relevant issues of the day. Thank you.
We did not connect.
Any other questions? Yeah. I know, buddy. I know. We're almost done.
I'm gonna take you up on the free legal advice.
Go ahead.
2 years ago, my friend was in a pinch, and his water heater broke, and I lent him $10,000, and we wrote a promissory note with interest, and he hadn't paid me. He still hasn't paid me back fully, but he started paying me back to my wallet in Bitcoin, and the promissory note had nothing to do with crypto whatsoever. It was just cash. So I was wondering if that's like a dumb move or does it matter?
Just talk. I think any lawyer can deal with that. So if you got a local lawyer who you work with before, that's a pretty straightforward debt recovery. So, anything else? Going once? Going twice? Sold. Thank you very much.